Welcome. Welcome to A Taste of Justice. I am Professor Angela May Kupenda for informational purposes only. I'm a professor of law at Mississippi College School of Law, but all interpretations are my own and are not to be ascribed to my school. Look, this semester I'm doing this series of short videos to accompany the longer ones. And with several of them, I'm telling you just a little short story about myself to help you in reviewing the concepts. In the last video, the previous video, we were talking about the difference in express rights and procedural due process and substantive due process. So today, in this clip, we're going to continue our discussion of substantive due process and the unnamed privacy rights. You're like, where did the court get them from? I don't see privacy listed in the Bill of Rights. The court says that the express rights give off shadows and emanations, that these shadows create a penumbra. There are zones of privacy. They are there, right? And so the court has looked at a number of instances and held that there are privacy rights within the Constitution, although not all justices agree that there are privacy rights in the Constitution. Let me give you some examples. Many years ago, do you know that in some states, married couples did not have a constitutional right to use birth control? Married people. But the court later held they got that privacy right. What is law enforcement going to do? Go tipping around in their bedrooms looking for telltale signs of contraceptives, according to the court. But then after married couples received a constitutional right to use birth control, you know, unmarried people wanted the same right, and the court did protect that right. Now, unmarried persons also have the right to use birth control or contraceptives. In the case before those, the court decided that there is a right to procreation, right? And in a case called Skinner versus Oklahoma, that I talk about in the longer video that I have linked before, where the state of Oklahoma was going to sterilize some individuals for stealing, but not sterilize those who were embezzlers. The court said, no, there's a right of bodily integrity. There's a right of procreation. Well, these cases can continue to add to, some people say expand, some people say identify the rights of substantive due process or the rights of privacy. Let me give you some other examples. The court says there's a right to marry. The court says there's a right to marry a person of a different race. Some states wanted to and did prohibit that under their state laws. The court also said there's a right to marry even if you're incarcerated in prison, that there is a constitutional right to marry. Now, the court did not say that the prison had to allow you to consummate that marriage, but the court said there was a constitutionally protected right to marry, and marriage could serve some individuals who are incarcerated well, especially as they plan to be released. The court talked about the right of a woman to choose to have an abortion, and then later reaffirmed that right. The court also said there's a right of same-sex couples to engage in sexual intimacy, and later the court said there is a constitutionally protected right of same-sex couples to marry. There is some right to refuse medical treatment. And the court has articulated that there is some right to palliative care, as such as in a hospice care, where the medications to make one more comfortable may actually be hastening the end of their life. The court says there has to be a right for that too. Now, I want to point out that none of these rights, though, are absolute. Just because there's a right does not mean the government cannot infringe upon them. In these privacy rights that we've identified, the general rule is that government should not intrude upon them unless government meets the most exacting scrutiny. It must have a compelling governmental interest, and its intrusion or its regulation must be narrowly tailored to that interest. Now, I asked the students in class, is there a constitutional right to commit suicide? And one student said, well, there is no constitutional right to physician-assisted suicide. And the student is correct. Now, just because there is not a federal right, the federal right is the floor. A state can decide that under their state law, they want to recognize such a right and provide accordingly. But the court has also said that they have never said there is a constitutional right to commit suicide, period. So even though the court has protected certain rights, there are others the court has said no to. There are some that get strict scrutiny. There are some that get maybe less scrutiny. And there are other potential privacy rights that have not been litigated yet in the courts. So I guess time will tell. But my story for you today relates to one specific case about privacy rights, Moore versus City of East Cleveland. Now, in Moore versus City of East Cleveland, there was a grandmother who had a home, and living in her home was her son, her adult son, and his child or her grandchild. So the three of them. But then another grandchild needed a place to live. And that other grandchild, who was not her son's child, moved into the home. So there were four of them. And the City of East Cleveland said, it's too many different people up in here. You all are not all closely connected. Our community, we want it to be more about nuclear families, you know, a husband and a wife and the two kids. No, we're not into all of these unrelated people or not closely related people, because they were related. The City of East Cleveland said, you can't live in this neighborhood with all of these different grandchildren in your home. Like I said, it was the grandmother, her son, his child, and one other grandchild. So the grandmother sued, and she said, our family is a family. We're not a nuclear family, but we are a family, and we have privacy rights, and we're all entitled to live together, the four of us. And you know what the court held? The court ruled for the grandmother. The court says every family does not have to look the same, that our country has a deep-rooted tradition in extended families with aunts and uncles and grandkids and what have you. And so therefore, the grandmother does have a privacy right to live even in this neighborhood with her son and her two grandchildren. You know, I usually don't tell students about my view on cases, but I like that holding. Grandmother did have that right. in my view. Look, it reminds me of a story growing up. I had an uncle, my aunts and uncles were, especially on my mother's side, were very engaged in helping each other and helping the children in the family. And I had an uncle who had a dream, he was a mathematician, of the family becoming more self-sufficient. So my mother and my siblings and we lived in a building that he owned. And also I had an auntie living there who was single. And it was time for me to take this standardized test. My guidance counselor was trying to help me get more scholarship money to go to college. And we did not have good transportation, but my auntie had promised me that she would take me to that Saturday morning somewhere across town to take my test. Now, the night before my test, my auntie was outside visiting with her boyfriend. They were in the car talking. And one of my sisters had some binoculars and was watching them through the binoculars and reporting back to us that they were going to elope that night. And you know what? My sister was right. All of a sudden, both cars were gone. My auntie didn't return home like the time she would normally return if she went out on a date. And late that night, she called and said she had eloped. And we were all so happy for her, for all of us. So she asked to speak to me, and I said, Aunt Evelyn, enjoy your honeymoon. I don't have to take that test. I'll take it another time. Or, okay, it's all right. You enjoy your honeymoon. She said, no, I made a promise to you and I'm keeping it. And she did. She left her honeymoon the next morning. She was giggling and she came and drove me to take my test. And she came back to pick me up after the test. As we were driving for her to drop me off, her new husband drove up beside us in his car, and he was just there. He looked over there in her car at her, and she was giggling, and I was staring, and he said, don't you, after you take her home, your niece home, don't you forget where you live now. Don't forget where you live, that you're married to me now. And she laughed some more and drove me home. I tell that story because I appreciate all of my aunties and uncles, especially my Aunt Evelyn and my Aunt Jane. They played a very instrumental role along with my uncles in our upbringing. And so they taught me some things about being a good auntie that I tried to be. So Moore versus City of East Cleveland stands for the proposition that privacy rights, family integrity rights do not just belong to the nuclear family. It belongs to the extended family too, with its rich traditions and care. Again, this is a short, but I wanted to tell you my story. And learning is so much fun. Learning will lead us to more freedom, to enlightenment, and hopefully one day to justice, or at least a taste of it. Subscribe and sign up for notifications. You don't want to miss a thing. Thank you, and I'll see you next week.